It's great to be here. First thing I want to tell you is that I'm not a lawyer. I just get to manage the conversation between these three fine folks. As Larry said, I was the Inspector General. I worked at the Central Intelligence Agency as my last job before coming back into the private sector. I also served in the Air Force, Office of Special Investigations, doing counterintelligence work very early in my career, at the Treasury Department, Inspector General for Tax Administration, doing internal affairs and external threats for the IRS. That was a lot of fun. And also at the Department of Defense IG, I also worked for Sam Nunn for 7 years up in the Senate Governmental Affairs Committee. And I was also the Democratic Staff Director for the House Intelligence Committee, where I actually hired Larry. So it just everything just keeps swirling around in this community. Yeah, most of you will work for me one day. Well, so the second thing I want to tell you is that the comments that you hear from me do not represent KPMG, and the comments that you hear from John don't represent his wife or Raytheon. The comments from Alex are his own. As a federal government employee, he's got that same rule, and as does Eric. So we are going to be talking about a lot of things that were raised this morning in the other panels, but chief amongst them is just privacy and civil liberty. A couple of you still have your Facebook accounts on, is that true? I trashed mine the second we were talking about behavioral analytics and Twitter. I don't think anybody in here is tweeting but you, Larry. So everyone else in the room shut down their social media instantly, and I also cut up my credit cards. All right, so what we've heard today is that, and if you didn't know, if you were somehow not in this environment until today, well, those people ran screaming out of the room after the first half hour, is that the relationship that we have, whether we're contractors working for the government or as government employees, or if you have nothing to do with the government, the relationship you have with your employer is one that's based principally on trust. The government, for those of us who have security clearances, the government trusts us to handle classified information. Just like, well, I might trust Doug Thomas with my wallet, right? But not my wife. So when you're looking at, because we do this risk-based analysis, we look at what we hold as value and as assets. And we make a trust determination about other people and how we're going to trust those people with what we value. And the government does the same thing in the context of national security information, or the same thing in the context of taxpayer information or financial information. When I was young and applied for security clearance for the first time, I filled out that Form 86. Charlie Allen remembers that. Well, he actually had to chip it away on rock. But that form was our disclosure to the government, and we trusted the government to maintain that information. And we did it once every 5 years. And so that consent and that intrusion, where the investigator went and knocked on the door once every 5 years, talked to our bosses, et cetera, those days are gone. Those are I won't call them the good old days, but they're gone. Because today, because of the information, the digital information, and the sheer volume of information that we make available every second about our behavior, as we heard earlier, it's observable. We make it observable. And we consent to the government not to check on us every 5 years, but there's a new thing called continuous evaluation that's part of insider threat, continuously evaluating us for that determination of trust. And so as we're standing up an insider threat program or programs or variations of it, it's largely to be able to take advantage of the disclosure of information that we're constantly making so that our behavior can be evaluated and trust can be maintained. And if we do something to change that paradigm, there can be intervention ahead of an espionage case so we don't end up like David Charney with his idea that if you actually decide you're going to spy, you can turn yourself in to stop the espionage. A great suggestion, Dave, to stop espionage. Because as we also heard from him, too often the spying occurs or the violation of trust occurs, and we, the government, might have an inclination that it has occurred, but we don't know who did it. And it's only when we get a defector that we find out who did it. And so that we're trying to change the paradigm with continuous evaluation, with the redetermination of trust. Okay, so that was a long intro to, or recap of this morning's session to say that, okay, fair enough. But now I find myself, even though it's 2017 and 1984, with Big Brother now able to see a lot more about what I do. And Big Brother in your mind can be your employer. I work for KPMG. I carry a KPMG iPhone. It's controlled by KPMG. Am I stupid enough to think that Larry's text message to me can't be read by KPMG? No. Do they care? Probably not. Are they watching? Probably not. But they've got the capability to understand and discern that behavior. Everybody agree okay? 10 years ago, that wasn't so. 20 years ago, it certainly wasn't so. So the capability of government, of our employers, has just gone skyrocketing past where we found ourselves 20, 30 years ago in that relationship. So what's it mean from a legal perspective? How in the world, get ready, John, how in the world can a private company like, well, let's just say a big aerospace and defense company, keep track of the trust relationship it has with its employees and, okay, so there's the first part of it, and vouch for that employee as they nominate that employee for clearance to work in the federal government? What's their authority? What's the legal authority for them to conduct background investigations or collect information, report it to the government, share it with the government? John.
Well, thank you.
You're welcome.
And thanks to INSA for having me today. So I think a couple of issues that you touched on. First and foremost, when employees at large aerospace defense companies, or any companies for that matter, submit themselves for security clearance, they're doing so with the express consent that their information can be monitored, whether it's financial information, their behavioral information in certain cases, depending on the clearance requirements, essentially everything about their background. So they're consenting to that. Many people in this room probably have those security clearances where you expressly consent. One of the things I think that is a best practice in the legal field is to, when you're part of that company, separate that process, that security clearance process, where you're having employees consenting to their information being collected and constantly monitored, to your point, separate that process from the work and the monitoring that you're doing of the employee on the private sector side. And here's what I mean by that. Taking the consent that I submit and say, okay, this is what I'm going to provide to the US government, my SF-86, whether it's online or in hard copy, however it may be, taking that information and having me, the employee, fill it out, submit it to the US government directly, so my security office at my company doesn't actually have a copy of that SF-86. So you may think to yourself, well, is that a good practice or is that a bad practice, right? Do I want my company to have it? From an employee perspective, probably not. From a company perspective, you probably do want them to have access to it. But it does provide that air gap, if you will, between the information being handled in the proper channels within the SF-86 review process, which is handled by the government, and your company's security office. Right, so you're sitting there saying, okay, from a legal perspective, that leaves a big hole, big gap, right? Back to your question of how do we make sure that the employee that the company is sponsoring is saying, yes, this person, John Martinez, should have a security clearance. How do they know that he has the right qualifications and should be in a position of trust? And I think that's where the second part comes in, where you really need to have a detailed process in your company to make sure you understand who's joining the company on the front end, so that onboarding process that we talked about a little bit earlier in the day, the monitoring process when they're there, and then that offboarding process as they're leaving. And I think all three of those have unique legal issues. I won't go into all the details. I'm sure we'll get into that in a moment. But suffice to say, I think in all three of those areas, the two most important things that you need, one is legal, one is non-legal, is employee consent. And consent needs to be informed. And when I say informed, it means needs to be the employer truly needs to understand what it is you're collecting, what you're going to be doing with that information, how you're going to be using it, how you're going to be sharing it, where you're going to store it, how long you're going to retain it, all that whole continuum of information. And if they don't understand that process and you don't have real strong governance over that process, I would argue you probably don't have well-informed consent. And I would also say, perhaps more importantly, you're going to lose the position of trust the employee has in the company to say, yes, I am willing as an employee to give this information over to my employer or allow them to monitor me in a way that I know they're going to handle it appropriately and accurately and not mishandle it. And I think there is that constant balance. I know Alex will talk a little bit about privacy, civil liberties issues, but I think more fundamentally in the company perspective, it's that balance between making sure the company has all the right processes and procedures in place and they're following them to instill trust in the employee to say, yes, I'm ready to give that information over.
Thanks very much, John. You know, we're really lucky. If you don't know Alex Joel has got an awesome job. You think being an AIG of the CIA is cool? Alex Joel is responsible to protect the privacy and civil liberties of all Americans, really, to make sure that the intelligence community doesn't overstep its bounds. And you've been doing this for a decade. Alex, I'd love to hear your perspective on informed consent. How many times you've filled out a form or just consented to something for the government? It's got that little Privacy Act thing at the bottom. That's your informed consent, by the way. How many times do we actually go in and sign things, and then 5 years later, the government's got a better idea or a different idea on how to use that data? You don't have to take that directly, but it's just a problem set.
Yeah, I do think informed, I mean, the idea that we have to think about making sure that people, when they're giving their consent, understand what they're consenting to is an important one. It's one that we've been exploring. I have been doing this for over 10 years, and when I first started doing this job, it's been 12 years now, I think. My office was the Civil Liberties and Privacy Office, and it was defined by the terms of the Intelligence Reform and Terrorism Prevention Act, and the focus was on civil liberties and privacy matters as we conduct our intelligence activities. And as people have heard, some folks here have heard me say in other contexts, we have a very extensive and robust framework in the intelligence community. We can always improve it to figure out how best to protect privacy and civil liberties while we're doing our intelligence mission. I call it a system of many layers with many players. It's quite complicated. And one of the lessons learned in the last few years has been that that is necessary but not sufficient. You do have to have all of these layers of rules and oversight. We have to make sure we have cleared oversight bodies to get the information in a classified environment so they can see all the secrets. You know, secret oversight, I think sometimes is spoken of as a bad thing. It's actually a necessary and outstanding aspect of our democracy that we have these other institutions that are clear to conduct independent oversight and see our most sensitive secrets. So that was important. We have been doing that, but that's not enough. We also have to have this other aspect of transparency. And the way that it works in this context is with the workforce. Does the workforce understand what we're doing with insider threat activities? Do they understand the risks that are posed to the mission of the organization from insider threats? Do they trust, to get to a point that you guys have both been making, in the employer, in the system, to look out for them, to treat them fairly, to handle their information properly, to use it carefully for authorized purposes? Or do they feel that they have signed themselves up to some kind of surveillance state where everything they're doing is second-guessed, and where the smallest little things that they do wrong can be used against them for an unfair purpose and an arbitrary purpose? So I do think, well, I think it's impossible in a counterintelligence context to give absolute transparency. Of course, it's impossible in any context involving intelligence activities. What I want to do is make sure that our workforce isn't shocked when something comes up. You know, it used to be avoid surprise. Well, you can be surprised by just about anything. Certainly, you would be surprised if I would be surprised if the counterintelligence community was focused specifically on me. I would be surprised. But I shouldn't be shocked that they're monitoring your government systems as you sign on to your government computer system. I shouldn't be shocked that they're taking insider threat seriously and they're pursuing different measures that are available to them to detect insider threat. So it's really providing that sort of sweet spot of information to make sure that the workforce understands what we're doing, why we're doing, and that in fact they're enlisted and they're part of that process and they want us to succeed in doing these things properly because they trust that we're doing it carefully. And it's not to say that there aren't mistakes and there aren't ways that we can improve on how we do anything, and certainly there are. One of the things that we want to make sure we encourage is that the workforce feels that they have trusted channels to raise concerns. So if they do have a concern, they do have a question, they can come to offices like mine, offices of General Counsel, inspectors general certainly, raise their concerns in a trusted way, free from the risk of reprisal. And
Not
that is a
WikiLeaks?
channel that they can use. Not WikiLeaks, right.
Right. Excellent, thanks. So, Eric, sometimes I feel like I'm the frog in the kettle. The temperature is just going up and I'm not even realizing it. So from a government wanting access to more and more information to evaluate behavior, what do we see, what do you think, where's the wall? Where do we bump up against, or where's the government bumping up against things that it would like to do but can't and might need some legislative action or at least a new agreement on use of data? Do you see those things coming up as you're working over at NCIX?
I think I do. I'd like to jump in on one thing if I could before that, David, and that is narcissist, Machiavellian, and callousness. Sounds like type A, strategic thinker, and a zealous advocate. And I was a little worried this morning's conversations were going to obviate the panel completely as we were going to be thrown out of the room. So sounds like a good advertisement for a good litigation lawyer, those three characteristics in some fashions. Thankfully, you can still have a job in the intelligence community with the latter three, at least, of what I just mentioned. I think the DIPMAC presentation highlighted those very issues that you were talking about. The Privacy Act was created in 1974. That may or may not have been before David came into government, I'm not sure. And so from that perspective, the Privacy Act, that creation of a law to dictate how the government's going to collect, maintain, use, and then disseminate information about the people that we're collecting it from is very important. It's an old rule, but as we've indicated before, it's stood the test of time, and it's very important that the government have a transparent way of indicating to individuals, hey, we're going to take this information, here's what we're going to do with it, right? We then have the statement or the system of record notices, which indicate how that information is going to be shared. And I really think that's where you're running into some of those challenges that you're having with insider threat programs. That's one of the things your lawyers are standing up. And they're looking at to say, hey, do we have sufficient notice to the workforce that for the reason we've collected this piece of information, maybe your HR record, can it actually be shared the way we want to now use it in the space for insider threat? And those are what the challenges are that we're looking for. Technology is always going to outpace policy, it seems, and this is no exception. And so they're going to continue to be challenges in that space. And there was a question back earlier today whether it's the law that's going to drive this or whether it's policy. It really is a policy decision of the government or organization. How much can we gain to make sure we've minimized the risk of insider threats? How much do we want to extract? How much are we willing to require consent for from the workforce till we do that? Because honestly, some of the fields that we're trying to recruit, hire, and retain, we have to make sure that we're not doing it in a way that is going to offend those people. We want to make sure that we can still get that talent into the cleared workforce. And for all the things that Alex said, that's how we do it. You've got to have an insider threat program that's based on trust. Trust of the individual to give you the information, but really trust that the workforce is a part of that process. We say it's based on the law. Executive order is part of that. It absolutely says to heads of departments and agencies, thou shalt have training for your workforce that includes what's the risk posed by an insider threat? What are the behaviors that are threatening to you? Maybe the individual in your workforce that you're seeing. Where and how to report those, and how the privacy is protected if you do it. Because again, it's really not a legal issue, it's a leadership issue for your organization and your leaders to make sure that we are not in an Orwellian state that was talked about earlier.
Thank you. We saw a lot of good things happen after bad things happen. Government seems to be able to take advantage of situations. I guess we all do. If there's a bad event, there's always a springboard of action based on that to move that pendulum swing. So if you pay attention at all to the news, you might be aware that it appears that for the past year or maybe two, there's been a concerted covert influence campaign being directed against the United States by a foreign adversary. Everybody like this? Okay. So if they are engaged in a covert influence campaign, and we know they're engaged in espionage activity, actively trying to recruit people who have got access to information, so there's the national security context, or if you work in, how many people in private industry? Okay, good. So you all have competitors. I'm a competitor of some people sitting in the front row, but I'm not trying to spy on them, or am I? Okay, so listen, so we've got a situation where information is power. And in the industry, as we've heard time and time again today, industry sits on an incredible amount of information that is competitive in nature, that's also national security in nature, might be some component of a bomber 20 years from now that's being discovered today. Realizing this, government has said, they've stood up an insider threat mandate after the 2011 executive order, and government is instituting that. Implementing that charge inside business, at least business that does classified business with the federal government, is a new conforming change that came out last summer. Most people know what I'm talking about. The NISPOM, Conforming Change 2.0. Everybody understand what that is? It's what requires all of our companies to stand up an insider threat program. And as we've heard time and time again, some are going at it just the letter of the law. We're going to be compliant. We don't want to be non-compliant, but we don't know how to go beyond that. And we've also heard that if you're not going beyond that, you really don't have a program. I've heard that a couple times this morning. So I guess what I'd like to do is hear from somebody representing a large aerospace defense company. Particularly from a legal perspective, when you get that charge, John, when that new standard comes down, what are the legal implications for a company that you have to wrestle with and give advice around?
So I'm not going to launch into all the requirements associated with NISPOM Change 2, but suffice to say, there are a lot of requirements that are going to be imposed on all sorts of nature of the industry, whether you're a large aerospace company with cleared personnel or a very, very small group. I think in one of the morning panels, somebody said, well, if you've got 20 or 30 people, you need to worry about it. Or this, I think they posed it as it's a rich company's problem, or the ability to provide a solution is more readily available from a rich company than it is from a smaller company. I think, let me point out just a couple of the precise legal issues associated with that I see from a legal perspective. First and foremost, I think the number I've heard, and I've heard differing accounts, is anywhere from 10,000 to 15,000 cleared contractor facilities. And so let's say take the high end of that number, and there's 15,000. They're not all the size of Raytheon, Boeing's, Lockheed's, et cetera, of the world. There's a lot. I mean, a huge number at that 10, 20, 30 people level. And you know, when you're a large prime, what you worry about is, well, I've got my insider threat program pretty well squared away. As somebody said earlier, sort of you're a big company, you have a lot of resources to put at it, you feel pretty comfortable about it. But none of us ever go to market alone. And who we go to market with are those 10, 20, and 30 person companies. And when we do that, do we look into their insider threat program? That is a real legal risk area. We're going to have real legal liability from it, possibly. More likely, though, we'll have business liability associated with that, where now all of a sudden we have some insider doing something wrong that was a sub on our contract that, quite frankly, you know, most of the primes don't look behind the curtain. And even if they tried to look behind the curtain to their subs, they wouldn't have access to that, because the subs would say, no, that's okay. I'm complying with the NISPOM. You don't need to look. I'll take care of it all. So I think that's sort of problem number one with it. And then if you just look at the words of it, you got to gather, integrate, report relevant and available information indicative of a potential or an actual threat. Actual threats, those are pretty easy, right? You know them when you see them, right? You know what they are. I don't know if I asked everyone in this room, what is a potential threat? right? That's the same, and you, when these things happen, you bring a set of facts to your lawyers and you say, hey, is this a potential threat? And we just sort of do the same, thumb test that you do to say, does that have the hallmarks of a potential threat? What are the indicia? What's direct evidence? What's circumstantial evidence associated with that potential threat? But quite frankly, the judgment on that spectrum is as wide as the 10 to 15,000 contractors that exist out there. Everyone's going to have a different barometer for that, and quite frankly, the government and DSS is going to have a different barometer for that.
So you went from, how many adjudication facilities are there? 7 in government? 7 CAFs? Let's just say there's 7 central adjudication authorities in the government. Now we have 15,000. Go ahead, I'm just helping you there. I mean, literally, you spread that out across corporate America making those determinations. And who gets to judge that?
Yeah, the NISPOM requires you also have to be monitoring your systems. Again, when you compare bigs versus smalls, the smalls have the capability or the wherewithal or the willingness, quite frankly, to monitor the systems and at what level are they doing it. That disparity, that subjectivity, I think is some of the challenge and the frustration I hear some people in the room say about the lawyers, right? And I think it's valid. At the end of the day, it is absolutely valid. When you turn to the lawyers and say, hey, is this a problem? Is this a potential threat? And we say, you all know, it depends, right? That's the answer you get back, right? It depends. Well, tell me more. I need more facts. I need more information. Let me compare this to the 16 others that I've had before it and the 20 others that are going to come beyond it. But that's the type of calculus we've been set up to try and make a determination on and say, hey, do we have a reporting obligation here or not? Because on the other side of the balance beam for the NISPOM, what I worry about and people in my position worry about is I'm going to make this report to DSS or some other agency about John Martinez and his potential threat. Is he going to turn around and is he going to sue me? And what is he going to sue me for? Defamation? Is he going to sue me for some employment discrimination? What are the things that is he going to go public with the fact that I am, over-reporting, and is it going to hurt my stock price and all sorts of things like that, right? So that's sort of the balance that you have to really look at and say, hey, do I have a legitimate concern, and that's sort of the standard we look at, a legitimate concern that this person has either a potential or an actual threat that I need to then go off and report. And I can tell you the language of the NISPOM doesn't help at all. It really does.
It was probably written by lawyers.
I'm sure it was. We did a fantastic job of catching everything and perhaps nothing all at the same time. Likelihood of risk or potential that an insider will use his or her authorized access wittingly or unwittingly, I'll come back to that, to do harm to the national security. So now you've got, John Doe, Jane Doe, he or she really believes they are doing everything that they should be with the information they've been entrusted with. And perhaps they are, but they're unwittingly, they don't know about how that information is being misused on their behalf. They have a fob that they left on the counter, and their kids had some friends over, and they picked up the fob, and friends had somebody who worked for somebody who was less scrupulous than their mother or father. And now all of a sudden you have that access. So the last point I'll touch on is the ambiguity in the NISPOM, which makes it challenging for all of you, which makes it even more challenging for the lawyers that you ask these questions of, do you just look at the cleared people? Because that's easier, right? Cleared people have given consent. We monitor them. They have periodic reinvestigations, soon to be continuous evaluations. And do you wash your hands of it at that point? Or do you say, you know what, I've got half my population who's cleared. I've got half that's uncleared. And maybe that uncleared portion is going to unwittingly help that cleared person perform some type of mistrust with that information. And I think that's some of the real challenges associated with the NISPOM when you look at it from a legal perspective, trying to balance all of the ambiguity with the real risks associated with market share devaluation, litigation, and quite frankly, and perhaps most importantly, erosion of trust by your employees. If they feel like you're over-reporting, running to the authorities every 2 seconds, every time you said to them, hey, I'm sorry, I messed up, I accidentally brought my cell phone into the skip for 30 seconds, and I walked it back out, right? You're gonna say, I've gotta report that. And now, okay, you do have to report that. What do you do with all the other steps of that employee? Do you do a full-blown investigation? Do you ask for their social media accounts to figure out what else is going on with them? Like, where do you draw the line as a company to say, hey, this is appropriate, this is a legitimate concern, I need to go to this point to collect information, gather it, report it, and go from there?
So if I could just jump in, John.
Sure.
So John, you make some excellent points. One of the things that two things jumped out at me. One is the potential part that you were talking about that's also a civil liberties concern. Not only is it a concern just in terms of understanding what that word means for companies and how they implement this, but from our perspective on the civil liberties side, you want to make sure that whatever indicators are being used are being objectively and fairly applied. So that really goes to my second point as well, which is that at a most basic level, you certainly don't want, and I know I'm preaching to the choir here, so I don't want to come across as wiser
okay.
than I am. You certainly don't want to focus on somebody simply because of race, ethnicity, religion, things like that. You have to tie those indicators to what we like to think of them as objective and observable behaviors, which is I know how this community has been talking about it, that are tied to a identified counterintelligence or security kind of threat. Not a specific one necessarily, but this is something that we have observed is tied to something that we have seen in the past as a threat. So the more objective you are, the better. And the fairly applied one goes to the last point you were making, John, because you could have a lot of different indicators, and human beings in the course of living their daily lives will get careless and sloppy and they'll make mistakes. And so maybe they forget to report something, or maybe they're very diligently reporting everything and all of a sudden they look like they have more reports than anybody else in their office. But what I think I've heard several times now from the workforce has been a concern that we are potentially gathering information that could be used in a discriminatory or unfair manner to go after a particular person. Maybe that person has filed a whistleblower complaint. Maybe that person is just a difficult personality. Maybe they always disagree with their boss, even though they're living up to their professional obligations. So it's really, you have to be careful on both fronts, that you're applying, the indicators themselves are objective and fair, and that how they're applied is also being done in a fair way.
Excellent. Eric, I think earlier we had somebody in the audience, or maybe it was someone on the panel, sorry. I'm getting old. When we have personal information, or at least information that we consider to be personal, is there a way the government should sort of segregate that, or is it up to us to segregate it? The earlier comment was at Homeland Security, they're not allowed to access their personal email, Gmail, Yahoo, et cetera, from their government computer. Everything they do on their government computer is official. Okay, so by its very nature, it sounds like there's no personal use of the government computer. Well, de minimis personal use, you're allowed, but I think is the wise employee not going to do anything personal on that government system so that the government has to, I don't know how they're going to get access to it if it's not on the system. Just bear with me. Flip it back over to somebody working at a large global consulting firm, where there's no, I guess de minimis or personal use, there's no scale there. I probably use my KPMG reimbursed cell phone more for personal use than I do for KPMG business. I think just if you took all my nighttime activity, et cetera. But the firm has access to all of it. See where I'm going here? So the firm can now, if they want to, since I'm covered by the NISPOM, look at my behavior all day and all night long. I have to go burn this phone real quick. So they can look at all of it. And versus the DHS employee who probably has a BlackBerry that they don't dare do anything non-government on, and a system at work that they dare not do anything private on. Can you talk to us a little bit about the ability to understand and discern behavior, whether or not we're going to have different classes of people just based on their operating environment? And then talk about the legal aspect of that too.
Sure. I think the The legal aspects are, is it's a decision with respect to your systems that's set up within your organizations, right? I don't think there's a collective, everybody has a de minimis use, doesn't have a de minimis use. Each agency head is going to make that policy. But then it comes down to the consents, and it really is that when you understand what you're consenting to on your use of that system. In every federal, I believe at least, organization, every system has a consent banner. When you log in to say, hey, use of this system will allow the government to monitor that system. So from that perspective, I think it is a safe assumption that whatever you do on that system is going to potentially be observed by the government. Now, whether they have the resources, time, talent, or care to look at every different aspect of that, that's a different question. But the fact of your logging on that system and use of it, particularly in the insider threat environment we live in today, is going to be monitored. Now, that is to some extent. Now, there's limits to that in that, for instance, it was talked about at the insider threat panel this morning. And that is that there are, within that executive order, it's about classified information. It makes very clear that classified systems are where user activity monitoring is expected to happen. And that is not necessarily true for unclassified systems that aren't otherwise connected to a national security system or involved in a national security environment. So there may be different levels that the agencies feel like they can go to monitor those types of communications, and that is that's a decision that gets made. I like the point that John made earlier, and that is when you're trying to hash out what you do. A great leader I worked for, not a lawyer, one of the agency leaders said to me, Eric, he's like, I want to know what's legal, I want to know what's illegal, but then I want to know what's legal but stupid. And keep me informed about that third category, because that's the big one that really matters, right? And that's really where it gets to, what's the messaging to the workforce? What am I doing in the public space that's such that I suddenly start to diminish folks' understanding or at least appreciation of the fact that I do understand their civil rights? Does the workforce appreciate and know what I'm doing in this space and why we're doing it?
So I do think, I'm sorry, John,
Okay.
that I agree with what you're saying, Eric. And the issue of bring your own device is something that's been talked about a lot these days in privacy circles. I'm going to be speaking at a privacy conference in a couple weeks, and they have bring your own device kind of sessions. So it's certainly a big issue for the private sector generally. I do think that one consequence of how the government has been doing it, and as you point out, different phones, et cetera, is that the employee can make a conscious decision as to whether or not he's going to use a government device that he knows is subject to monitoring versus using a different device. And that goes to a different point that we've always been focused on, at least from the government's perspective, is because of our Fourth Amendment implications in terms of, if the government does something, it could trigger Fourth Amendment protections. I am very focused on making sure that we're looking at government systems to which the consent banners have been applied and the policy and the training, et cetera, around the government systems. If we start going beyond government systems to try to look at what people are doing outside of the four corners of the consent that they signed in their SF-86, then you start getting into very sensitive areas, and we get very concerned about that. But user activity monitoring on government systems with the banner, where people have the ability to make incidental personal use of that system, and they're doing so knowing that that incidental personal use is also subject to monitoring, I think that's a fair outcome.
But what NISPOM has done, John, maybe you want to take this, NISPOM has now, without that kind of clarification and guidance, pushed 15,000 companies in to create an insider threat program. Well, fine. If I've got access to my employees' personal use on their device, should I be looking at it? Am I in trouble if I don't?
So let me quickly respond
Sure.
to something that panelists have said. Back to this point of consent, I know we keep harping on it because we're lawyers and it's this fascinating concept for us of what really is consent in this day and age. And it goes back to your first question, actually, your very first question, which is, we get to consent to continuous monitoring, and it's very different than that one period of time, 5 or more years, that I sign my SF-86, I consent at that moment, I close it up, and I wait for the next one. The consent piece of this, I mean, take a quick show of hands. I'm sure most of you who either work in government or work on a a company system, you have a consent banner. When was the last time, who read their consent banner? Today. Last week. Last year, right? I mean, it's the same banner. You just click OK and you go through it. How many times have you read the Apple iTunes end user license agreement? Pretty much never, right? And even for the lawyers, you get like 2 lines in, you're like, oh, forget it. I just want the song, right? And you say OK. So, I think the real question is, do those consent banners, is it meaningful, informed consent at that point? I don't know. I think we're starting to get away from the fact that it's actually meaningful consent when we say, well, we had a banner, we had them click through it, that's all okay. And here's what really I think is scary for the lawyers, right? So this study, which was fantastic, by the way, the study talks about behavioral aspects of employees' everyday actions. And I know there's technology out there that can decide whether I'm happy or sad today. And they know that because I'm clicking the mouse.
Charlie used to have mood ring.
I'm clicking the mouse a little slower or a little faster than I did yesterday. Or I'm responding to my boss's email maybe 2 minutes later than I usually do on average, or 10 minutes later than I usually do on average, or just not at all, right? And does that mean I'm more disgruntled? I'm more likely to now take company proprietary information, classified information, and start misusing it, selling it? I don't know, but where's that line, right? And I looked it up because it felt like it was yesterday, but perhaps showing my age a little bit. There was a great movie about, in 2002, called The Minority Report, with Tom Cruise, Spielberg movie. These precogs would be out there trying to predict whether you were going to commit a crime. And the name of the unit that Tom Cruise worked in was called the pre-crime unit, right? And he would say, well, hey, and I never forget the scene. They bust into this guy's house. I think it was the person Tom Cruise was going after. They bust into his house, and they arrest him. He says, for what? He said, for a murder. He said, what murder? Of your wife, who's standing right there. And he's like, she's right there. No. You're gonna kill your wife, and you haven't done it yet, right? So when do we start passing back over into this world in the counterintelligence space, where all of a sudden we start to say, well, you were clicking the mouse a little slow, or you weren't responding to emails quite as often. Maybe you're showing up at 9:15 instead of 8:15 every morning, or you're leaving at 4:15 instead of 5:15 every evening. What does that indicate? It gets back to this privacy and civil liberties issues, but I think from a real legal perspective, the way wonky legal lawyers think about this is, what are you consenting to when you have that big banner and that continuous evaluation? I totally avoided your question.
But it was a great answer.
Yeah, if I could jump in, by the I love the Minority Report analogy. I used to use that back in the day when it was more relevant to people. So.
When people remembered.
That movie's been out for 15 years. It's actually a great analogy. But I think there's 2 different aspects of what you're saying. So one on the consent side, which is an important thing. It's like, what do people actually understand that they're consenting to? So that's a legal and sort of a policy question. And that is really more, we focused on that on the collection side. So if you're thinking about the way that lawyers in the intelligence community typically analyze things, that you collect information, you retain and analyze it, and then you disseminate it. And you can think of that sort of construct here as well. You collect information, you analyze it, and you make decisions based on analysis, and then you report certain things. We've been talking about collect, analyze, and report. So what you're talking about with the consent banners is really on the collection side. Do people understand that we're collecting all of this incidental personal stuff that you're using on your phone? And we, being the employer in the private sector. And on the analysis side so I was focusing on making sure that we're using objective behavioral criteria and not making judgments based on somebody's race, ethnicity, religion, et cetera. But what you're pointing out as well is sort of this concern around automated decision making. And we have a data mining reporting requirement that Congress enacted about a decade ago in response to Total Information Awareness, the Poindexter program, which was a research and development idea at the time. And that's where I used the movie references at that time, was really, do we want computers making a decision as to somebody's potential guilt or innocence? And sometimes lawyers get enamored of words like algorithm, right? So people will say, well, the algorithm indicates this person has a higher threat, risk of threat than this person. And we say, well, if the algorithm says so, it must be true. So we really have to open up that black box from a legal perspective and a policy perspective and understand what are the factors, how are they being weighted, what is behind that determination, to get to your point exactly, which is we don't want people to be reported or stigmatized in any way based on factors that once you look at them don't hold up.
Great. All right, Eric. In the same context, when we're talking about informed consent, and I want to talk about publicly available information now. So lots of us think about social media. We think about what we put on Facebook or tweet, what somebody else might have written about us in a blog, for example. All publicly available information. So I'd like you to talk about what that world looks like in this context of, is it available to the government? I also want to talk about subscription data. What can the government actually buy that may not be out for us to look at, but's for sale? So I'm not making this up. Well, yeah, I am. So if all of a sudden the federal law allows Verizon Fios to take all of our use of its data, okay, so Fios says, okay, they know where we've been and what we watch and what we do, right? They got that. But now they're allowed, without our specific consent, to sell it. Now, I don't know what it is, but let's just go to the worst case scenario. Your personal browsing history for the last 6 months is for sale. And your teenager. That belongs to them. They want to understand where you've been so they can sell you more stuff. And Google knows where you've been, and Amazon, so they can sell you more stuff. But what if they suddenly said, hey, FBI, would you like to buy this for $1 million or $10 million? Can you talk to us about that, Eric? What constraints there might be around that?
I'd call your FBI lawyer. That's so to the second part of your question. That's a good one. And then the point that I would make is before the government is able to collect any type, or source of information, we have to have a purpose to have it, and it has to be related to a mission set that we have. And so in those types of scenarios, we would have to be looking at that very closely to determine whether or not that's something, a browser history, for instance, would be something we would really need, want, or even desire for the purpose of security clearance processing. The first part of your question involved publicly available, or what we call social media information. That is something that is coming into the, I have kids now that are 10 and 8, and they know more about social media than I do. And so what is on there, and what is the risk in that space? Last year, the DNI issued some guidance at the request of executive departments and agencies to say, hey, listen, is there a threat here? We need to be able to go evaluate that, or we want the authority or at least direction to say, yes, this may be something we want to do. And so the DNI did put out some very specific guidance in that space, and to basically say to those agencies and organizations, if you're going to do it, you're going to do it on only publicly available social media information. Perhaps those in the CI community in the room would be like, well, that's not going to get me anything. But that is where we are right now. It's publicly available information, and those agencies and organizations have to set up a program to do it, and they have to come back to the DNI and say, hey, this is what we're going to do when we go ahead and run that.
But they're going to do it.
Whether they're going to do it and how they're going to do it. There's some pretty prescriptive type language, even in that directive that's fairly short. For instance, it says you can only collect on the covered individual. Obviously, you can't direct your collection to collect on the children or relatives, those types of things. It also makes clear that you cannot ask for passwords of individuals or log into the accounts, force them to log in the account when you can watch over their shoulder, right? That would undermine the whole point of being publicly available. So that's the. But again, I think that's a reflection, Dave, that it's not 1974 anymore. There's a space out there where
1984.
It's 1984. There's a space out there where there's information that people are posting and putting out there, and we need to be careful in what we do with it and how we use it.
Alex, make us feel better.
Well, I
Well,
thought
make me feel better.
have a directive. The directive isn't commanding that people use to go to social media. It's putting out their guidelines on how to do it if you're going to look at social media as part of the background investigation. And the stress is on. If somebody is broadcasting to the general public that they got, that they have some kind of problem that would otherwise disqualify them for a security clearance, well, we don't want our background investigators to be ignorant of that fact. I think it's a very logical thing to contemplate when you're thinking of one background investigator looking at one person's file and saying, I wonder what he's been posting on his blog, and oh, by the way, he says he fully supports Al Qaeda and has just sent them a bunch of money on his blog. I should know about that as part of the background investigation. It's a different story when you're looking at some commercially marketed products which claim, again, to do this risk scoring based on what people are posting in social media. So I think that is something that we want to look very carefully at, the kinds of concerns that John was raising earlier.
Great, thank you. All right, we've got about, looks like 8 minutes left. So I want to take a couple questions from the audience. There were several things that we didn't get to up here. Yes, sir. Microphone up front, please. Please state your name and...
Thank you. Kirk Paulson,
Yep.
still,
Yep.
for the third time. So I want to go back to the question about, or the discussion about publicly available information. Is it your opinion that a private company needs to make any kind of a notification to employees that they may look at publicly available information as part of their insider threat program?
So our
First
directive,
part. The second part of my question is, are you aware of any case law in which a company used publicly available information to discipline an employee?
so I would like to defer that to John, but just generally in terms of privacy circles, and this issue gets discussed quite a bit in terms of employers generally, not necessarily in the context of a security clearance investigation, but just generally speaking, to what extent can they look at social media, and are they looking at social media for purposes, for example, before they hire somebody to vet qualifications. So it's a very common issue that's been coming up over the last few years, and I think companies are all over the map in terms of how to deal with it.
Yeah, no, that's exactly right. I think all of my colleagues that I talked to, some are heavily into the social media space, both for CI monitoring, but also for hiring decisions. Other companies are exactly on the other side of the pendulum. They say that's not an area we're going to look at. And I think that candidly, there's probably good arguments for both. I think some of the pitfalls associated with looking at some of them, just to maybe tell you where my head is at least. I'll invite you into the deep, dark recesses of a legal mind. But so the real danger there is when you have an employee decision that you're about to make, whether you're hiring somebody, terminating them, providing an adverse report to DSS or otherwise, and you're about to make that decision, what you want as a lawyer is to be able to march back into the government or into a courtroom and say, hey, this is the criteria that I used. It's repeatable, it's consistent, it's fair, it's balanced, the employee was on notice about it. And when you get into the social media space, it's a lot harder because you don't know what you're going to find. You say, well, okay, I'm going to look at their personnel file, I'm going to look at their evaluations, I'm going to get interviews from the people that they worked with, and that's what I'm going to make my decision on. But then you get into the social media site and you say, well, they're part of this political group, or they've given money to that political group, or they seem to be drinking a lot in these photos, or what those decisions are, and it really starts to erode the criteria that you need to have a defendable decision, and that's what I think makes some of the lawyers concerned about it. But I think where it does work for those companies that do use that is they do have the objective criteria and say, hey, you can only look at publicly available, you can only look at these things, or here's the only things that you can use in your decision-making process, and they outline the guidelines and standards that are to be used and defended when it gets called into question.
Excellent, thank you. Yes, sir. Question? Oh, I got one. Oh, yes, sir. There's one back here.
Hi, my name's Alex Hoover. I'm from DHS. Just actually a comment first. Philip K. Dick used the word pre-crime in the short story Minority Report in 1956.
That is correct.
So think about that for a little while. So from the perspective of lawyers on the panel, and I'm not one, I'm happy about it, how do you deal with the employees and what I will say is a massive misperception of what actually is private in the internet space, and their perception of that as opposed to the reality of what's publicly available, what you can do, and how do you manage that chasm, I'll say.
Yeah, please. Alex, Eric?
I would just say, I think I understand the gist of your question. One of the things we do when we're setting up a program or recommending it to an agency would be, listen, don't do the minimum, right? Don't do the minimum standards. Yes, people have noticed that they log into every day, but make sure you're doing workforce notification, right? Make sure you're doing frequently asked questions on your security page. There's other ways, and that's exactly right. You want to be in a very defensible space. When I told you the leader wants you to give him advice, keep me from doing something that's stupid, it's, hey, the way you bring that pendulum back is you put people on notice. You reinvigorate that consent and make sure they understand where the limits are, what you're going to do to the extent that you can. And I think that's helpful for any agency. I don't know if that happens in private industry. I suspect it does as well.
Yeah, I think one thing you've heard consistently today, to address this inside the workforce, you need HR, legal, not just the security and CI people to handle this. You've got to get your ethics and compliance, the people that are used to talking with the workforce and listening to the workforce much more than CI security ever do. It's that team approach and getting the best practices from those HR professionals on how to communicate and how to over-communicate. Any other questions for the audience? We've got literally 2 minutes left. Sir.
Thank you. Brian Smith from Beacon Global Strategies. Question on the DNI's guidance on use of social media. Does that apply to the whole government? So was it issued under his authority as the security executive agent?
Yes.
Or to the okay.
Security executive, it's SCA, it's SEAD 5.
So the whole, it
Yes.
applies to the whole government. And more generally, to what extent are policies actually standardized across the government, notwithstanding the guidance?
Asking a question that he knows the answer to.
Yeah. Anybody want to just say they're not, or?
Based on the guidance, like we tried to point out, I think Alex did a very good job of highlighting, is it's to those agencies that want to institute one of those types of programs. And so it's incumbent upon them to develop that policy. And to date, we don't have anybody that's publicly done one in a full scale. I think there's a couple that may be beginning to pilot in that space. And so to the extent we have a pilot, we have a couple good lessons learned. Hopefully it's not a litigation lesson learned. Then we'll have some more clear, and I suspect, consistent policy.
Yeah, I think there's, and I know that the folks in this room know about this, and we've talked about it at prior conferences. I mean, there's not unanimity on the value of social media information in the security clearance context. So some people think it's valuable. I mean, obviously you can pick, certain cases where, the person posted something that was inconsistent with what they put on their application in a material way. That kind of situation, it seems of obvious value. But to do it on a large scale involving a large number of people, there's a lot of issues, not least of which is making sure that you're looking at the correct social media page for the person who's who's the subject of the reinvestigation. So it's one reason why it's not a cookie cutter solution for everybody is that we need to see how different agencies implement this and what lessons learned they have as they go.
Listen, I want to thank our panelists. I want to thank Charlie and Kathy and Doug for their leadership in putting this on every year, but particularly the three folks up here for volunteering their time. Thank you for your attention, and we're going to turn it over to Harvey.
Great. Thank you. We're going to move right into our next panel. So if you do need to take a break, please make it quick. Let's get our next panelists up here. But thank you to